Hey guys, welcome to my channel. Today's courtroom starts with what looks like a routine agreement to settle a long-running property dispute, but within moments everything takes an unexpected turn. A family member steps into the conflict, serious accusations are made, and the judge is forced to address a situation that threatens to spiral out of control. Did someone cross the line inside the courthouse, or was it simply emotions boiling over? Stay with me as we break down every dramatic moment and reveal how the judge restored order.
Governor, please support. I think that Ms. Roberts and I have an announcement on the Blakely matter.
All right.
Governor, what we've got here is I had filed a motion.
Mr. Blakely here.
Mr. Blakely?
Yeah, Ms. Blakely.
Your Honor, what I had done, we had gone to mediation in this matter and we had partially resolved it. We entered a partial settlement on July 14th of 2021. I filed that mediated settlement with the court. And in that mediated settlement, the parties agreed to use Ms. Carrie Parker Perry with Parker Perry Properties to get the fair market value and list it with her for sale. And it would be placed on the market. Each party was to cooperate with the sale, keep the home in fit and habitable condition so that it would bring the best price, and they would execute all necessary documents to list it and ultimately sell the property. And we agreed at that point in time that once it was sold, if we could not reach an agreement otherwise, all the proceeds would be deposited with the clerk in an interest-bearing account. Well, it didn't get put on the market, so I filed a motion to do it. And Mr. Potter and I have discussed it today. And so with the court's approval, what we would like to enter the order today to state that the house will be immediately listed for sale as is with Ms. Parker Perry as the listing agent. Once there's a contract, mutually agreeable contract reached, Baker's Title will close the property. And after the proceeds of the sale, all necessary costs of closing and the outstanding mortgage, which has an approximate balance of about $63,000 will be paid. At that point in time, $82,500 will be deposited into the registry of the court in an interest-bearing account. And the other proceeds will be divided equally between the parties. And at that point in time, both parties are going to, under the mediated agreement, it still says both parties are going to cooperate with the sale of the property, keep it in a fit and habitable condition, and sign any and all necessary documents to get it listed and ultimately to get it sold. The wife is currently in possession of the property, and it is being sold as is. So we wanted to clarify on the record, it's being sold as is. Nobody has to do any repairs, but nobody can do any further damage. And neither one of us, neither party is waiving any right to argue as to whether the total amount of the proceeds were marital or non-marital or partially marital. And argue the $82,500 is going to be deposited, what an equitable division of that would be. And should the property diminish in value or anybody take overt action to reduce the value, we also have the right to argue about the reduced equity. So that's what we've reached. And Mr. Potter, did I leave anything out?
No, ma'am. I think that is the agreement, Your Honor. The reason the $82,500 is being paid into the court is there's an argument. There's no agreement between the parties, but there's an argument that my client intends to reserve and make to the court that those were funds that she paid to purchase the house from insurance proceeds from the death of her former husband. We want to make sure, and Ms. Roberts announced it correctly, that the order is going to say that neither party is waiving any argument they have regarding whether or not the house itself was marital or separate. We've just agreed that we're going to have this division of money, but that doesn't mean that we're conceding that the house itself was a marital asset. We reserve all those arguments.
Either party could have to pay the other one back from the 82 or from their separate funds. So again, it's just a situation. It's getting the house sold consistent with our proposed agreement.
And putting some money in each party's pockets.
All right, Mr. and Ms. Blakely, if both of you will raise your right hand, let's place you under oath.
Do you solemnly swear or affirm the testimony you give in this house will be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. and Ms. Blakely, I will start with Mr. Blakely since he was the plaintiff. You've heard what your lawyers announced and that the agreement is regarding these matters. Do you understand that agreement?
Yes.
And do you believe that, or are you willing to abide by that agreement? You understand there'll be a court order from this point forward?
Right.
Mrs. Blakely, I'll ask you the same thing. You understand what your lawyers have worked out? Is that correct?
Yes, sir.
And do you understand it's going to be a court order from here on enforceable as a court order?
That's right.
All right, then I will approve your agreement.
Okay, well, I just. Okay. 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 All right, thank you, Your Honor. We will submit an agreed order to that effect. Your Honor, may we address the court after one short minute?
I'm not sure. It's never a good sign when the parties have announced an agreement and they walk outside and immediately turn around and walk back in.
Has really nothing to do with the parties, Your Honor. As we were exiting the courtroom as an officer of the court, I want to inform the court as to an event that transpired. As we were exiting the court, I believe it to be Mrs. Blakely's father, Mr. Pepper, who's seated here at the end of the row, was holding the door. I told him I had it. He said, no, come on through. As I passed by, he accosted my client. There had previously been a threat made prior to court saying that he brought extra money today because he got arrested. And he accosted my client. It happened in the parameters of the court. I believe it's indirect contempt. And I would request the court to address it if I could play in that, whatever the court deems appropriate.
Come up here to the podium. Ms. Roberts, let him have the podium for a moment.
Sir, this has been a disaster from the beginning. This has been a mess. Mr. Blakely walked out on my daughter, left. Everything was fine. She didn't know where he was for 3 days. He finally called and said he was just tired of it. He was gone. It was directed through the mediation. I understood that both of them would work together to get the house in where they could sell it. He has made no attempt. He has done nothing. He has left it completely on her. They have accused her of tearing the house up, sir. She had a flooding problem. She had a drain line stop up. It flooded the basement of the house. She spent money getting it done, getting it repaired. She called John 4 times the night that it did. He would not return her call, sir. He didn't know if Gavin was sick. He didn't know if something was bad was wrong. He didn't care. Anyway, she got it repaired.
Let me interrupt you and just say this to you.
Sir?
I said, let me interrupt you and say this. I want to treat you with respect because I know that you're concerned about your daughter's situation, but I want to explain a couple of things to you and do so in a way that I hope that you can understand my position.
Yes.
That you are not a party to the lawsuit. Your daughter is probably the most important thing. And so you just listen to me and you don't have to respond. Okay. I want you to just listen to me. The fact of the matter is that I have a daughter and I understand as a father how you would feel about your daughter and how you feel like she's being treated. And under the circumstances, all I can tell you is this, that we have a lawsuit that's pending and that we have made an agreed order that the parties have agreed to through their lawyers, and that they know what the legal ramifications are and what the legal guidelines are that we have to follow. My job as the judge is to try to be fair to both sides. And as a father, it would be hard for me to not be partial to my daughter and not to feel like my daughter had been mistreated if this was the same situation. I understand that. But and at the appropriate time, we may be able to give you an opportunity to come into court and to testify about that if that is necessary. But when we conduct a proceeding like we are doing today, one of the most essential things is that we have to keep order and we have to keep the peace between the parties. And we can't have people that are saying things to each other and provoking some sort of a dispute. You have every right to feel the way you feel. I understand why you feel that way. But my job is to tell you, please do not ever let that happen again, because I don't want to have to hold anybody in contempt of court. And that's the remedy they give me. The remedy they give me is this, a hammer that says I had to send people to jail because they've disrupted court. I tell people in jury trials, in criminal cases, where there's a lot of emotion, we just tried a couple of big ones. And I've had to tell people when the jury comes back, sitting in the courtroom, maintain your composure. You can't do that, leave, because I don't want to have to put you in jail for disrupting a proceeding. So while I sympathize with you and I understand your feelings, I have to tell you, please do not put me in a position where I have to address that by you saying something to one of the others. You just be quiet. I understand. I'm not saying that you did what has been accused of you. I'm just telling you, my job is to keep the peace in this courtroom and outside of this courtroom, everywhere within the doors of the Justice Center or my jurisdiction. And for that reason, I have to tell you, when you leave here today, the best thing you can do is just keep it to yourself until you have the opportunity to come into court and testify at the appropriate time. Mr. Potter is a very good lawyer. He will help represent your client. Ms. Roberts is also a very good lawyer, but she sees things from the perspective of her client. And naturally, if they could agree, we wouldn't have a lawsuit. So while I want you to understand that I want to give you the opportunity today to voice what you were upset about. Now that we've heard that, what I'd like to do is just make sure that you understand that my court order is that there'll be no further kinds of communications of any kind of threats or any kind of, not that you've done it, but there won't be, him towards you, you towards him, or anyone by anyone else. Is that clear? All right. Then with that admonition, then I'm going to allow you to step back and then we will go ahead and address anything else. Ms. Roberts, I believe that successfully addresses the issue.
Other than the fact that he got up in my face and pointed his finger in my face, and Your Honor seems to be justifying his actions and telling that you understand why he's acting the way he acts.
I understand why.
Record, I want to say that there's two sides to this lawsuit, and I can disparage his daughter in a way that would not be that would be inappropriate for me to come up here and state what I have known. But again, it's not appropriate for any individual who is in the confines of this courthouse to verbally accost another individual, much less an officer of the court.
I agree with you 100%. All I'm simply saying is that I'm trying to make this gentleman understand that I understand as a father why he would feel strongly about his daughter, but he is not allowed to do what has taken place. And you understand that, do you not? Then under the circumstances, if you accost the lawyer again, then you will go to jail. Do you understand that? You make a threat, you make any kind of statement. I'm not advocating that he is correct in what he was saying or that he was correct in what he did. I'm trying to avoid it from happening again because there's only one remedy that I will have. All right. I believe I've successfully dealt with it. So.
This case proves that even when legal agreements are finally reached, emotions can still create new problems if they are allowed to take over. The judge reminded everyone that the courtroom is a place for law, respect, and self-control, not personal confrontations. In the end, the strongest message was that keeping the peace is just as important as resolving the dispute itself. If you enjoyed this video, don't forget to like, comment, and subscribe. Thanks for watching, and I'll see you in the next video.